like to bring the Planning and Zoning Commission meeting for October 17th to order. Please rise for Pledge Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Madam Secretary, please call roll call. Please.
Mr. Lund?
Yes, ma'am.
Mr. Odell?
Yes, ma'am.
Mr. Grande?
Yes, ma'am.
Mr. Saunders?
Yes.
Vice Chair Townsend?
Yes, ma'am.
Chairman Reynolds?
Yes, ma'am. Any announcements?
Mr. Chairman, I think the only thing I'd like to announce at the beginning of the meeting is that it appears we will not have a December meeting consistent with our past history, unless something vital and important appears. Our last meeting for 2014 will be in November.
Thank you. Any disclosures? Okay. Review the minutes from the September 26, 2013 meeting.
Move approval. Second.
Any discussion? Madam Secretary, can you call roll, please? Or no, those just, any opposed? So moved, okay. All right, on with our first item is going to be ordinance number 13023, road impact fees.
Good evening, Mr. Chairman, members of the board. Mark Satterley, Planning and Development Services Director. For the record, tonight we are considering a couple of minor changes to all of the 7 impact fee ordinances. The changes are all the same through ordinances 13-03 through 03029. However, as my understanding, and the Assistant County Attorney can confirm this, that we will have to take, I think we can discuss them all globally, but have to take, whatever action you all take individually on each ordinance. Just before we start, the ads for the impact fee ordinance amendments, public hearings were published in the October 7, 2013 version of the St. Lucie News Tribune. Tonight, real briefly, we don't have a long presentation. However, we have invited Dr. James Nicholas to join us. He is going to provide just a brief history of impact fees in St. Lucie County. Dr. Nicholas has been the county's impact fee consultant since 1986, I believe. I think Dr. Nicholas was one of the inventors of impact fees. And he's worked with us over the years on all of our impact fees, as well as all of the periodic updates we do on the impact fees and the methodology and the data that we use to support our impact fees. So he's just going to make a brief presentation talking about the history and some of the underpinnings of our program. And I'm going to make a brief presentation about the proposed changes. Ms. Gowan is here, our OMB director. She is going to address the changes that we're proposing to the rate that we will pay on refunded impact fees. And then, so of course, we'll answer any questions that you have. Mr. Wilson is here. He has asked to make a presentation about some of the, we've had sort of an ongoing dialogue with him about our program and refunds and things of that nature. He would like to make a presentation to the board. And then we'll move to our well, it's his public comment. It's part of the process. So with that, I will turn it to Dr. Nicholas just to provide you a bit of background on our program.
Mr. Chairman, members of the Planning and Zoning Commissions, good evening. As Mr. Satterley said, I'm James Nicholas. I've been around on this issue longer than any of you. St. Lucie County was one of the first to actually adopt impact fees as we know them today in 1986. The ordinances that you are looking at tonight began there. Much of it is still the same today. as it was originally written in 1986. And if you look at other jurisdictions' impact fee ordinances, you'll notice a great deal of similarity because your ordinances have been copied all over the country. They were well done. I didn't do them, so I'm not trying to take the credit. Julian Juergensmeyer, my colleague, was the primary author. But you'll notice a great deal of similarity in the language, and we find most working under those same principles today. As I think you know, there is no Impact Fee Enabling Act in Florida. Rather, impact fees were found to be legitimate exercises of the police power by local government. The Florida courts, through the Supreme Court, found this. And like any police power action, they exist to serve public health, safety, and welfare. And an impact fee serves as one mechanism to provide roads, libraries, schools, fire protection, all of the things, all the 7 things covered by those 7 ordinances. Because there is no statute to refer to, the courts look generally to the question of were the actions taken reasonable? And in this case, of course, the impact fees used to protect health, safety, and welfare. And out of that came guidelines, which we've followed here from the beginning and through today. And that primary guideline is known as the rational nexus test, which I know a number of you have spent a great deal of time with over the years. Very simply, the rational nexus test has 2 components. First, that the fee cannot be more than the local government's cost of accommodating the impacts of a development. Well, what if there's no impact? No fee. Now, what if there's no impact because the development is never built? No fee. What if you've already collected the fee? Refunded. The simple logic of the rational nexus test. And then, of course, one of the issues is, well, how do we hold the person harmless who paid a fee that wasn't necessary? You pay them interest. And then the question comes, what interest rate? To which the answer is one that is reasonable. In 1986, when these ordinances were drafted, some of us can remember that very easily, the interest rates were very high. Mortgage rates went up over 17%. Regular interest rates were commonly 10, 12%. In that context, the statutory interest rate was 6%. And that got picked up and put in this ordinance, all of the ordinances. With 20/20 hindsight, what we should have put in was a variable rate that went up and down with interest rates in the marketplace. But hindsight wasn't all that good back then, and the issues were focused on how much is the amount of the fee, which is usually what we argue about. And you've got one side saying it's too much and the other side saying no, it isn't. But here, no one addressed the issue of when a refund occurs, what interest is to be paid, and that, of course, is now the subject before you this evening. So it's the rational nexus test that goes through. The cost cannot exceed more than the cost of the impact. The fee, pardon me, cannot exceed more than the cost of the impact. What if there's impact? No fee. And then, of course, what if the development would have had impact if it had proceeded, but did not? Well, then, no fee, but fee has been collected, refunded. So that would be considered to be reasonable under the rational nexus test, and of course the amount of the interest, again, would be one of reasonableness. Others will discuss the specific on what interest rate is proposed here and the mechanisms of how to, in fact, get that refund to the individual, but I just wanted to explain briefly the context in which these issues exist and ultimately will be judged. Mr. Chairman, I'll be happy to try and handle any questions now in the process of the evening that I can. Thank you.
Thank you. Any questions?
Can I have my other mic?
You need the other one? That one wears out. We'll get you the other one.
Dr. Jim,
Where's our vacuum?
what I would like to get some information about is the concept that we've always used in the past of holding the impact fee for 10 years and then refunding it. Is the 10 years that is kind of memorialized in St. Lucie County, is that as a result of any state law, or is that a local choice?
So there is no state law.
Okay.
It's a local choice, and it too, Mr. Grandi, must be reasonable. Now, with respect to the 10 years, which some might say, well, that's a long time, a road from concept to drive on is very commonly 10 years, with all that that entails. And that's where the time period came from. Is trying to track how long it takes to get these done. Maybe that's too long, it shouldn't be that long, but nonetheless, that's where that 10-year period came from. There's no state law on the subject. There's no case law on the subject. It's not come up in any litigation.
I believe that. I can't imagine that anybody who has paid it would have ever challenged the 10 years. The question that I have really is, if you've read the proposed changes for us, we're looking at implementing a process where I think after 2 years we proactively attempt to refund it. And then another year later, if we've failed to contact the permit holder, we take another shot at it. And so my question really is, or my comment really is, I don't understand why, if we're going to make those proactive contact attempts and we fail, I don't know why we wouldn't at that point own the money, and why we should carry that liability for another 7 years, if you will.
Mr. Chairman, if I could, and I will go through the presentation, and we'll cover some of that, but I think Mr. Grandi, we're talking about two different things.
Yes, we are.
One is the fees that are paid, the house gets built, the money goes into a capital project, or goes into a fund for a capital project, but that capital project never gets built after 10 years, then that person who paid that fee, built that house, created that impact, would then be eligible to get his money back. The process that we're talking about is somebody pulls a building permit, pays their impact fee, never builds their house, or even starts construction on their house, gets halfway done and abandons the project, the permit expires, that house, even though it's half built, still has no impact on the system. That person is eligible for an impact refund. Rather than have that money go into a capital account or be somehow spent, we're proposing a little different. So it's to address that. It just addresses a little different issue. And if I can make the presentation, maybe it'll become clear.
Okay, but the only thing that I do notice is, having made the house wasn't built, the impact wasn't there, the money is really due back to the applicant, and we've made, certainly according to the proposed changes, reasonable attempts to return it. My question is, why another attempt years later?
Let me go through the presentation,
Okay.
and we'll address that issue.
One point I would like to make clear in this context, I'm sorry I didn't make it in the main, is that while every jurisdiction I'm familiar with has a refund provision of the type you're looking at tonight, most simply refund if there's no construction started. If the construction has started, then the impact fee then goes with the land, which means they wouldn't have to pay an impact fee in the future if they restarted the construction. But St. Lucie County has decided to have, if you will, a more generous view of this. If the construction is never completed, then they would entertain a refund of the amount. I've had this come up to my practice here a number of times since the Great Recession started. It wasn't much of an issue before then. And my advice has always been, it seems like a silly thing to fight over. You know, go ahead and deal with the refund issue. The development never happened. The impact never occurred. Refund the money reasonably. Move on. When somebody picks the project up, whether it's completing the home that was never finished or starting anew or whatnot, then of course an impact fee would be paid. So it's not like the county's actually giving up impact fees. It's not. It's a timing question. Because you ultimately will get that fee as long as an impact occurs.
Any other questions?
Mr. Chairman?
Mr. Lowndes.
Dr. Nichols. Through all the presentation that you've made to us and everything about impact fees and such have you, is a different view of impact fees simply a fine for coming here to live?
Well, certainly some people would view it that way. The rationale for the impact fee is that developers commonly are compelled, required to improve the infrastructure. And one of the ways of doing that is to make a cash payment in lieu of actual construction. And that's what an impact fee is. It's a cash payment in lieu of construction, which is why you'll find in the impact fee ordinances probably more time than anything else is talking about what somebody, or how to treat the impact fee rather, when somebody actually builds, a developer builds a road or something to that effect. What does that do to the impact fee? Because you can't hit them twice for the same thing. So it really is an issue of developers assuming some degree of financial responsibility for the infrastructure improvements required. And again, an impact fee is one way to do it. The other way, of course, is the actual construction and or dedication of improvements.
I ask that because some of the folks that I see from time to time ask that question. Yeah. And it needs to be part of the record.
And Mr. Chairman, if I could, Mr. Lowndes, to your statement, you know, there's the mantra that you hear oft repeated that development pays for itself, new people move into the county. You know, that this is an effort towards that, is to, you know, is that somebody builds a new subdivision, you know, 300 new people move in, they're going to demand schools, roads, infrastructure, and that the existing residents shouldn't underwrite all of that cost, and that the new people underwrite some of that cost.
Mr. Satterley, I get it, but okay. It needed to be in the records as to why it's not a fine for moving to this county or a county. It is actually an activity, an active fee to overcome literally your impact that you have on the community, that we would have to pick, we citizens that are already here would have to pick up, or the county would have to forfeit in taxes to overcome.
Commissioner, the repeat of the rational nexus test, the fee cannot exceed the local government's actual cost of accommodating the development. So it's not like it's Christmas and St. Lucie County, you know, is making money off of this. It's a cost-driven calculation, and it falls within that concept of a fee, not a tax, and it cannot exceed those costs.
Professor, many times it's short of what is the actual cost.
That's one of the unfortunate aspects of the process. Is first, we're using averages, and we're using averages of past costs,
not future.
Not future.
Not estimated future cost. It's past.
That's right.
Past costs that were real then.
That's right, and that came out of all the litigation. The courts wanted to see, you know, what did it actually cost to build that road, which meant we're looking backwards. And then there's all sorts of other things that are the extraordinary costs that road may have entailed. are subtracted out. But virtually every road has an extraordinary cost. Every school has an extraordinary cost. So it's a process that goes through that when you wind up with a number at the end, which is argued to be reasonable, it almost invariably is low.
Mr. Grande?
Yeah, I think the points that really need to be driven home for the folks that are watching in the audience and on TV is we don't really have a choice of either charging impact fees or not, because the charge for the impacts themselves is going to be borne by the county. You can't bring children into the county and not provide schools. You can't bring developments into the county and not provide roads outside of the development. So the impacts they're going to be paid for.
One way or the other.
You have no choice as to whether or not you're going to pay for the impacts. So then the philosophical question is, who pays? Do the existing folks pay for the impacts of the people coming in, or do the people coming in pay for their impacts? And over the years, and Dr. Jim and I have been arguing, discussing this for more years than I can remember, what's happened in St. Lucie County is there is a negotiated end to this. The county has never taken the position that 100% of the impacts are paid for by the new people, because having new industry, new people come into the county is part of growth. It's good for the existing folks. So we make some contribution, they make some contribution. It's usually a negotiated number, and that's the main reason why the impact fee is never really enough to cover the total cost of the impact. It's in St. Lucie County, it's viewed as enough to pay the portion that the new folks should pay.
Mr. Sadley, would you like to go ahead and do your presentation at this time?
Yes, sir. Thank you.
Okay.
As Dr. Nicholas pointed out, we had our initial road impact fees were set at 86, and since then we've added 6 more for libraries, public buildings, parks, law enforcement, fire, EMS, and schools. Impact fees are currently collected at the time of building permit. Those collected funds are then diverted into capital accounts to help pay for expanding services. The economic downturn has seen many requests for refunds. St. Lucie County has refunded about $157,000 over the past 3 years. We retain a small percentage of fees for administration, and then as Dr. Nicholas has pointed out, since the initial impact fees were adopted, we've been refunding at 6% per year. In looking at the potential amount of refunds that we have out there for expired building permits, it is somewhere in the neighborhood of north of $800,000. So you can see where, if all that money gets refunded, that's a potential budgetary issue, because those monies are directed into capital accounts primarily for roads, and those are budgeted to make those roadway improvements. And if we are refunding all that money, that's money that's no longer available for those road projects. So with this, we've proposed two revisions for refunded fees, and the first is to create a 3-year time frame for refunds. But that comes with some policy decisions that we're proposing, and that at the time of CO, or I'm sorry, at the time the permits are paid or the fees are paid, those monies are directed basically into a holding account or an escrow account, rather than going directly into the capital account. And then at the time of CO, once a CO is pulled for that project, then those monies are put into the capital account. If there's no CO, what we typically do, well, I would say if there's no CO, we are going to reach out and offer refunds of those dollars. And the reason we figure we can do that is that we already notify, in our building department, we already notify building permit people that pull building permits that their permit is about to expire. And so it's not a great leap to simply add on to the letter that we send out that your building permit is about to expire, and if you have pulled a building permit where you have paid an impact fee, you are potentially eligible for a refund of that money. The reason we've stretched it out is to 3 years is because we found that we have a number of those permits that have started to age. I mean, they've been around in our system for some time. We think that reaching out on more than one occasion, and perhaps 2 to 3 occasions, probably makes some sense in order to get a hold of that fee payer. Some people choose not to have their impact fees refunded simply because they know that they have already paid their fee. They may still want to go ahead with their project. That fee's already paid. That's a sunk cost for them. They just have to come in and pull a new building permit. One of the issues that Mr. Wilson had raised in previous email correspondence that we've had was about construction. At what point, would we issue refunds for projects that have actually gone to construction, as Dr. Nicholas had discussed? And initially we thought, well, if you're under construction and you started building your project, you've created the path to an impact. Well, in reflection, we said, well, you know what? We have a number of projects that got a slab in, got partly built, and then were abandoned. There is no impact. Consistent with our policy in the past to interpret liberally our ordinances, we felt that, if there's no impact, we will offer the refund. And then people have the option to say, you know what, leave that there. I plan to go ahead at some point in the future. Or they say, you know what, I've abandoned the project. I want my money back. And then they understand that in the future, they or somebody else who comes in to finish that project will have to pay that impact fee. And then the other item is, as we've discussed at some length, is to change the interest rate paid on refunded fees from the current 6% to a rate not to exceed the Florida prime rate. In the ordinances, we had to put in or not to exceed 3%. We've decided that that's probably not necessary, that Florida prime rate tracks state investments, and Ms. Gowan is here to kind of explain that further. I can only explain it to make it confusing. She can probably explain it so that you can understand it. But that is a reasonable rate. That's a rate that's contained within the state of Florida. It's consistent with monies that we get and receive in investments. So that the 2 changes that we're going to propose to the ordinance that you have in front of you, one is to eliminate the 3% cap, focus on the Florida prime. So that's the variable rate that Dr. Nicholas was talking about. And then the second one is to change that refunds should be, requested within 3 years from the date of permit expiration rather than from permit issuance. And that would be consistent with our policy of beginning to reach out to people that have permits that expire. After 3 years, if we reach out and we get no response, then it's our determination at this point that those monies would go into the capital account. And then, somebody comes back to us after that period of time and says, you know what, geez, I didn't get the letter. Then they have the ability to go to the board and ask them for that refund. But, we feel that if we make legitimate efforts to reach out to people, tell them that their money is available, multiple occasions, that at some point, that money goes in. Then, speaking to your point, Commissioner, that after 10 years, we would do the same thing again. And then there may be, their successors and assigns are referenced in the ordinance. And if we can get a hold of those successors or assigns, then they too might be eligible for that refund if those monies are never spent.
Mr. Chair.
So just that's, our recommendation is that we move forward with a recommendation of approval to the board with the 2 changes that we've offered, and we're here to discuss it further with you.
Mr. Grande?
I believe I understood your presentation. If you look at page 2 of the explanatory memo, under item C, I think it says, "Will retain the unspent fees in the escrow account for up to 3 years after the permit has been issued." I believe that should be expired,
Right.
Shouldn't it?
Yes.
Okay, now I think you'll find that in each of the ordinances, that same correction needs to be made. That is, the ordinances reference 3 years from issue as opposed to 3 years from expiration.
Right, yeah, and that was, the recommendation is that change be made from the date of issuance of the permit to the date of expiration of the permit.
Yeah, I guess what I'm saying to you is the ordinance as it's proposed
Oh, right,
is incorrect. It should say date of expiration.
right.
And the proposal
exactly
does say.
That's right.
Mr. Chairman, Commissioner Grande, that is one of the changes that we're recommending in addition to what you see before you tonight, is that be made, and again, in all the ordinances, that same language.
Okay, so the ordinances that go to the commission will have that corrected.
We'll have that corrected, we'll have that change, and we'll also have the 3% annually stricken.
Okay. Now, before we go on to the other presentation, let's get back to the 10 years. I understand the 10 years for the guy that actually did the construction. Whether I agree with it or not, I'm not sure, but I understand it. But for the situation where the guy, the project just never got off the ground, you did make the good faith attempt to reach him when it became apparent that the permit expired. 2 years later, you made another attempt, and a year after that, you made a third attempt. Is there a reason why at that point you're going to maintain that liability for another 7 years after the expiration of a permit of a project that has never gotten underway?
I think we would have to, and correct me if I'm wrong, but I would think that, we would have to maintain that liability. One, where would the money go if there's nobody to give it back to, in that period of time? And then also, I guess, after 10 years, if the money goes unspent, that and all of the other money that would have been assigned to that project or in that account that has gone unspent would also have to be refunded.
What do we do now if a project is built and the road impact fee has been designated for a road project that doesn't get built, and the money ages for 10 years, we wind up giving it back, right?
And we've never gotten there that I'm aware of.
Right,
But
okay, but what I'm saying is, if at the 10-year period, they didn't apply for it and we couldn't find it, we couldn't find them, don't we move that money into the general fund?
Mr. Chair,
Mr. Dale?
wouldn't the rules change a little bit if that's going into an escrow account instead of a capital account?
Mr. Chairman, Mr. Odell, I'm not an expert. I use the term escrow simply as a term of art. I know that there's a whole laws that go along with it. It's a holding account. It's somewhere not in the capital account so that it can be held and not counted on for a capital project.
It would be based on whatever the terms of the escrow are.
Okay.
Dr. Nicholas?
Chairman, Commissioner Grande, in the explanatory memo on page 2, items C and D, I think answer your question, that after the 3-year period and the attempts to notify the individual of a potential refund, if they are unresponsive, the money will then go into the capital account and become available for expenditure. Now, what Mr. Satterley was pointing out is that doesn't necessarily close out that individual who comes in 5 or 6 years afterwards, but they would have to go to the board and make an argument of equity of why they should get a refund. But it doesn't just allow those monies to just sit there and vegetate, if you will. After that period, it moves into the capital account, which means now you have 7 years to make productive use of those funds rather than the full 10.
I absolutely understand that. What I'm saying is we couldn't find the guy when the project went belly up, if you will. We tried again a couple of years later. We tried a third time a year after that. And we're not going to spend the money. Why not assume that money at that point rather than waiting for the 10 years to expire?
It does. At that point, it goes into the capital account.
No, I realize that, but what you're saying, it goes into the capital account, But if this guy or his assigns or successors pop up after 8 years, even though it's already in the capital account, we're going to refund it.
Well, that'd be up to the board.
Right. And what I'm saying is, you're about to make a recommendation to the board now. Why don't we take this opportunity to straighten that out? That is,
I mean, I guess, Mr. Grandi, what's your recommendation? We seem to be not answering your question.
if it falls into this category of a project that never got off the ground, the permit expired, the situation that you're dealing with
Right.
now, according to what I read of your changes, you have made every possible good faith attempt to proactively notify the guy that we probably owe him some money.
Right.
And failing at that, you waited a bit and did it again. And failing at that, you waited and did it again. I think you've now satisfied every reasonable possibility for a refund, and that money probably should no longer be eligible for being refunded.
And I think that's what we're saying.
No, if I read this correctly, it says, we're now going to move it to the general fund, but if it's not spent in the 10-year period,
But that's how it is.
it's eligible for refund.
But that's, okay, I see what you're saying. And I guess that would just be consistent with what we do now. And we may never find that person. You know, that money may never be found. Fortunately, we haven't been in the position where we haven't been able to spend the money. You know, we've always been able to find places to put those funds, but, you know, we just haven't found a way to cover every single
You're
base.
missing what I'm saying. What I'm saying is, even if you find a place to spend the money, according to the changes that you've made, you're going to refund it.
Mr. Chair.
We're going to try to refund it only if the project never gets built or the monies never get spent. And what you're saying is that regardless, we should assign that money to a capital account and not seek anybody out even after 10 years, is that
Right,
it?
because if after 3 years, if after all your attempts you've moved it into the general fund, it may or may not get spent, and now it's independent of the project, and now this guy shows up after 9 years and says, I paid you the money, you should be giving it back to me, and you're going to do it.
At that point, it would be a board decision.
Mr.
Not
Chair.
according to this, I think it's...
That's not how I'm interpreting it, but I think if that's a recommendation that this board wants to make, you know, we're certainly willing to forward that on to the Board of County Commissioners.
Mr. Mott?
I think if it's made clear that at the end of the term, the applicant would have to appeal to the Board of County Commissioners. I think if you just add that clearly,
Okay, we
understand what Mr. Grandi is saying. So
another point I would like to make, just while I'm thinking about it, these ordinances are, and this is another issue that we've discussed with Mr. Wilson, is that these ordinances are only forward, only after this ordinance. It does not apply to anybody that's paid a fee prior to this ordinance being enacted, you know, falls under the old rules, you know, that doesn't apply to anybody that's out there right now. So this only applies to permits, building permits and fees that are paid after the day that this ordinance becomes effective.
I think Mr. Grandi's point is that even after the expiration of the term, there may be extraordinary circumstances
and
somebody would like to have reviewed.
And we have that, we thought about that, and we think that's entirely possible, that somebody's going to say, you know, I was, you know, overseas fighting in, you know, wherever, and I didn't get any letters. I had no idea. You know, there may be extraordinary circumstances. So, you know, I think you have to leave that.
As I think we said, just make it clear that there is an appeal process, please.
Any other questions for staff? Mr. Lowndes?
Mr. Satterley, a question possibly for you and for Heather. Is there any statute of limitation involved in any of this?
I would probably defer to Dr. Nicholas, but I'm not aware of any.
I No,
So I think I asked that earlier. Dr. Nicholas said it's not covered at the state level. This is all handled by our local ordinances.
that's correct. Thank you, Mr. Chairman. Mr. Lowndes?
What does it cost if we put the money in supposedly an escrow account? What does it cost us to maintain those accounts on a yearly basis? Is that covered in that difference of the prime, the Florida prime?
Mr. Chairman, I don't believe I'll let Marie answer that, but again, we hold back, depending upon the specific ordinance, we hold back a small percentage of administrative fees, which I think anticipates, that there's a administrative holding processing cost affiliated with these fees.
3 or 4%, depending on the fee.
Okay.
I don't know why.
Yes, ma'am.
Good evening. My name is Marie Gowen. I'm the OMB director. There's no fee. We're not charging any fee to hold it. What we do is it's not really an escrow account outside of the funds of the county. It's just that we're holding it separately until the time such that it expired. Then we move it into the capital fund so it could be used.
It's another pigeonhole that we don't play with.
Correct.
Thank you, ma'am.
Any other questions of staff? This time I'd like to open up the public. This is a public hearing. Open up to the public. I'll come forward, please.
Oh, thank you.
I see you've been waiting there patiently.
For months. Good evening, Commissioners and staff. My name is Charlie Wilson. I'm the president of Impact Fee Consultants in Vero Beach, Florida. And Dr. Nichols is the father of the Impact Fee, and I guess I am the grandson of the refund, I guess, because that's, 2 years ago, I started working on refunds, and I think I was the first in the state of Florida, and we've become experts at refunds. I don't blame you for being confused. There's a great deal of confusion in the statutes. There's a great deal of confusion surrounding refunds. They were not well contemplated when the first statutes were out. I want to start off by praising your staff members. We've done this in a lot of counties, and your staff members are exemplary. They've done a wonderful job. At the same time, some of these things are issues that haven't been determined and are really outside of their area of expertise, actually anybody's area of expertise. I can tell you that some of the questions before I start this little presentation, some of the questions that have been asked differ from county to county, and some of the questions that have been asked are understandably difficult to understand. Mr. Grande, as an example, I believe that the answer to your question of why you can't just put it in the general fund is because it is collected based on the dual rational nexus test. And the only two things you can do with that are to spend it for the proportionate share of the person that, in this case, did not build, or to refund it. Those are the only two expenditures that can be made out of an escrow fund for impact fees. And the state statutes require you to put that into a separate account, accounted for it separately. So it's very much like the state of Florida collects refunds for utility payments, insurance payments, bank things, and they send it up to Tallahassee, and they have to keep it forever until they do some sort of auction after a great number of years. But because this is based upon the nexus, that's why it goes back to that. Because if you then spend it for something else, you have broken the nexus. And one of the things I wanted to point out, and we've talked a lot about why.
Sir, please, let's keep in mind that's an interpretation. And the assumption of that interpretation is that money will never get spent, which never happens.
Okay. There are half a dozen things that have not been litigated that are just about to be litigated. And one of the things you have to keep in mind, however, is that and I have a couple of examples in here, is where courts are now demanding counties to repay this money. They demanded $700,000 in Nassau County. They demanded money in Lee County. They demanded over $4,500,000 from a county in, I think this was in California. But I have some of those examples, because what you really need to do is make sure that in your refunds are not a raid on the Treasury. Refunds are there for a couple of different reasons. One is that you promised to give it back. When you did this to start with, you made a promise to the people that paid it. You had a contract to the people that paid it. And so...
We're not discussing that. We're talking about when you can't give it back. You physically can't give it back.
Yes, sir.
There's nobody left who was a party to the payment. There are no assigns, there's nobody out
Heirs
there.
to the estate.
Yeah, they become heirs. But what happens, sir, is well, first of all, I don't want to jump around on this issue. But the answer is that if it doesn't meet the nexus, then it endangers the county, because the county then is going to have to litigate this matter. And there are other things in the county rules that have not been litigated. 10 years has not been litigated. The idea of whether a planning or a zoning member, a planner, has the ability to decide when construction begins. The whole issue of when construction begins. Because I can tell you, you're in interlocal agreements right now with Port St. Lucie and the city of Fort Pierce. Port St. Lucie, Fort Pierce, Indian River County, and St. Lucie County all have different interpretations of that very thing. And it has become very clear that that is probably going to be the next litigation. But I don't want to get so far into the weeds of these things quite yet. There are, I hesitate to go through a 20-minute presentation when part of that's already been made. So perhaps I can ask a couple of questions. One is, the administrative functions are really not before this board tonight. Is that correct? Because this board doesn't really establish the administrative functions of the 5 years or 10 years or any of those things. So really the only thing before this board tonight are essentially 3 or 4 issues that are of utmost importance.
Mr. Chairman, I've got a question of Mr. Satterley and Ms. Young. The monies that go into an account, a capital account for expenditure, let's say on sidewalks, and the area is out west, and rather than building a sidewalk, they give a donation, if you will, or a payment towards sidewalks in the county, and we then can build the sidewalk anywhere in the county, and it doesn't have to have a nexus to the party that gave it. Are we talking about the same ability that these monies that we've collected would not have to be directly made or expended to the benefit of the payee, that we can use those monies if we move them into a capital account for, as long as it's for highway, as long as it's for school or fire district, as long as it's within its capital account, we can spend it anywhere in the county, and it doesn't have to be a direct nexus to the payee?
Mr. Chairman, Mr. Munt, I'm not sure I entirely understand your question. When you mention sidewalks and say a fee in lieu of, it's a little different animal, but I think even there has to be, a nexus between the payment that a developer makes. If he's going to say, I don't want to build that sidewalk because there's not a sidewalk on my road, there's not going to be one, but the county has a requirement you build a sidewalk, we put that into a sidewalk fund, there still has to be a nexus, there. But in terms of...
well, let's just say the impact fees that are paid. It's the county's discretion where they apply those monies for a project.
Well, it is, but we follow our capital improvement plan and our transportation improvement plan, and those monies have to be allocated to those projects. We don't have a very long list of projects. We have Kings Highway, Midway Road, Indrio, and maybe a few projects like that. But, we do have to expend those monies within that period of time. And as Dr. Nicholas pointed out, when it comes to a road project, 10 years, the DOT will tell you that from concept to concrete is sometimes 14 years. So it can be a long time, but we do have some discretion in the projects and what they get spent. We haven't had an issue not spending, road impact fee dollars. Did I answer your question?
We're getting there.
Can I,
I think if
I can do my presentation, then I might be able to answer some of those questions.
Mr. Wilson, with all due respect, a 20-minute presentation is an awfully long time.
That is, we're not going to remember the questions unless we ask them of you as they come up.
Okay, well, that's just fine. I believe, and I apologize for my getting confused along the way, but it's just like anything else. You have to build from the beginning. And one of the parts that we have to build from is the idea, not from the point of view of how to put in an impact fee, but what are the restrictions? And there are restrictions that limit the county's ability to do things. The county does not have unlimited authority when it comes to impact fees. And sometimes counties forget that. They are limited by the fact that counties cannot levy a tax that is not legal. And that's why they had the nexus test to make this a fee. And by agreeing to this being a fee, there are some restrictions on the county. The county, as an example, has a restriction of there was a court case, Wald versus Dade County. The court refused to review the constitutionality of extraction under a merely reasonable standard, a highly deferential standard that would have provided local governments with too much unfettered discretion. The state statutes require that it go into an escrow fund to be used for that particular district and in that particular usage. So in some cases, if you have multiple districts, then any of those funds would have to go in and stay in and be accounted for in that district.
Mr. Wilson, I'll tell you quite honestly, if you're going to quote, cite cases of law, you're before the wrong board. You need to take your facts and present them to the county attorney for their opinion and their deliberation about whether it's applicable or not, not ask this board to make a decision either, for or against what it is that you're presenting to us, and have us make a decision, predicated on your presentation.
Well, sir, let me make sure that I am very clear. The first thing is that I have met with the attorney, and the second thing is that we have worked out to an agreement almost all of the issues that we have brought up, and we have discussed these. I am attempting to let you know what some of those are, because from the questions that you're asking, some of that information you don't seem to have. So I'm here just to try to be helpful in this education process. Frankly, it doesn't really matter to me what happens here, because what's happening is courts are going to make these decisions. It's not me bringing them. What I'm trying to do is trying to be helpful, to tell you that in some cases, the county does not have as much discretion as sometimes they believe. The fact is that a court case, and I believe your consultant will tell you, that the court case that established really the rules for impact fees, established that 6 years was, as an example, was a reasonable time. Now, they didn't say that 7 years was unreasonable or that 5 years was unreasonable. They just identified that 6 was.
Well, with all due respect, Mr. Wilson, if we're talking about adopting regulations which are to fall within legal parameters, our county attorney's department should be the one that's telling us what we can do and not do. You're about to tell us about some items which are still under litigation and still don't have the ruling of the court, and I certainly can't move on something that hasn't been litigated at this point and a decision rendered.
Well, they have been litigated, sir, but I don't. If you don't want to hear it, then I don't need to tell you. So, that's just fine. I'm happy not to tell you.
I'm just telling you that if you've worked something out with the county attorney's office ought to be the party that's telling us, here are the facts and here's what we should be doing.
Oh, I'm sorry. I thought it was a public hearing, and that's what the public was supposed to do, was to come and tell you.
Mr. Wilson, you've got 5 minutes as far as I'm concerned, and you can say anything you like.
Mr. Chairman?
Oh.
Can I make a suggestion? I hate to interrupt, but somebody's making a presentation, and I think it would behoove us to let him make the presentations. If we have ideas and thoughts, we should be intelligent enough to write them down and ask those after he's through with the presentation, then close the public hearing and let the board have a discussion afterwards.
All right, Mr. Wilson, if you can just continue your presentation, please. And if anybody has questions, just write them down and we'll ask them as it goes.
Mr. Chairman, I'll go through this as quickly as possible. The 4 things that were of utmost importance were the retroactivity, which they have which the county staff has mentioned. And the county attorney has recommended some language to insert, just like you made the change, Mr. Grande, in the permit section. There is a change that needs to be made to insert language that shows that it is not retroactive. Even though this county understands that, what you may or may not know is that you're in interlocal agreements with cities, and they don't understand that. So when you, and those interlocal agreements intertwine the county with those operations. In this case of the city of Fort Pierce, they defer to your law. So when you change your law, you're changing theirs. So one of the things so the retroactivity was important. The definition of no construction. The definition of no construction is, in our opinion, really dealt with by the nexus. It varies from county to county. You can take any chance you want to. You can see what the courts have to say. But what I was trying to do is to advise you that the court precedent so far has been that if there is no CO, there is no impact. And that is because the state building code says you cannot live in a house without a CO. You can't live in a house without a CO, you can't go to a library, and you can't be a resident. So as a result, you cannot be charged an impact for a non-impact. It was the same situation with seniors in a all-senior housing development, cannot be charged for schools. And that was a decided court case because it was an exemption. The third I was doing just to try to be helpful, and that's the section with the interest rate not to exceed 3%. I wrote a memo to the county that said that probably was not past legal. It doesn't make any difference to me, and they haven't done that. And then the next item is the unworkable notice procedure. The actual procedure that you're using is really unworkable. And the reason I can say that is because we have seen this now, and we have seen it tried. We have seen it tried in Indian River County. You can never get to a perfect list. You're going to leave somebody off. You're going to put somebody on. Some people in Indian River got paid that weren't supposed to. Some people weren't paid that were supposed to. It's just because of the nature of putting the list together. It is complicated by the fact that a lot of times your impact fees are collected by the city of Fort Pierce and the city of Port St. Lucie. The city of Fort Pierce records are woefully inadequate. Now, the state statutes require you to keep the records, and it also requires, and I'm sorry to talk legal language, but I don't know what else to tell you, is that the burden of proof is on the county. Usually when you're in a situation, somebody making an application, the burden of proof is on them. But the state legislature changed that. The burden to prove that you did impact fees correctly is on the county. And that is part of the state statute that allows impact fees. So the notice, there's only 2 counties that I know of. There's no requirement for notice at all. There's only 2 counties that I know of that tries to do notice. Indian River is one and Hillsborough is another. Indian River was completely unsuccessful. Although they returned, and you've returned 175,000, they've returned 3.2 million, largely because that's what we had them do.
What do you mean by unsuccessful?
I'm sorry?
I think you just said that...
Oh, their notice was unsuccessful. And it's because 3 things came into play, and I don't want to use up all my time.
What unsuccessful means.
Okay. The 3 things that were unsuccessful is they were not able to create an accurate list. And you're in the same situation. You don't have access to a completely accurate list because your list, your payments are being collected by 2 cities that you don't have complete control over. Okay. The other unsuccesssul part of the Indian River County operation is that they had people that were missing from the list. And they also had people that we ended up paying. So it's the difficulty in obtaining a completely perfect list as opposed to somebody making an application and then checking to see if they were eligible. If you take the thousands of people who have paid impact fees to check and see if every one of them is eligible, as opposed to waiting for an application and then checking to see if that person is eligible, it's a huge, huge difference. Very expensive, and you're going to have a Department of Impact Fee refunds to be able to establish that.
Excuse me, we can't do this, wait till the end, because the amount of detailed questions here is incredible. Now, when you say eligible or ineligible, you mean?
As an example, First of all, you have to have a person that has paid impact fees. So you've got a list of people who have paid impact fees. Then you have to have people who have expired building permits. So that you have to have people who have paid impact fees that have an expired building permit. Then you have to have someone who's paid impact fees, has an expired building permit, and then there's 15 other things that you have to check.
And no CO.
And no CO. As an example, it could be a land split. Your records could show that they paid an impact fee for a piece of land, and then that building got built, and then there's a vacant property next to it. So all I'm trying to tell you is not to tell you.
Real quick. Mr. Satterley, I've got, basically, aren't we tonight, it's just the interest rate and refund? We were no policies or anything like that. It's just to determine an interest rate and forward it to the board.
Right, and I think the issue that Mr. Wilson is getting to, in terms of finding the people, we really haven't had any difficulty. You know, once Charlie made a public records request, we went through his list. You know, we were able to add and subtract from the list. We were able to find the people, and you know, we reached out. We've been able to refund the monies for the people that Mr. Wilson has represented. So, and we have the staff, and we're able to do that. The interlocal agreements is a little different issue, but again, that's not an issue for this board.
Right.
You know, if we have an issue with the interlocal agreement between the city and PSL or Fort Pierce, you know, that's something that we have to work on. But you know, we're still recommending that we adopt the two items that we were talking about tonight.
Yeah, and
There are
one of the
items.
things that we've decided is that this is not retroactive.
Right.
Okay, so this is only going to apply to people paying impact fees from now on.
Correct.
So the concept of our old records may not be accurate, doesn't matter a whit. The idea is now that once we adopt whatever we adopt, it's on us to maintain the records that are necessary for implementing those refunds from this point forward. And it doesn't mean anything as far as how accurate our records are from our past impact fee collections as far as what we're doing tonight is concerned, because that's not retroactive. What did I miss here, Charlie?
You have 4 items in the actual piece of legislation before you. The first item that we wanted to bring to your attention was the retroactive nature, and that we have a memo from Mr. McIntyre.
We've all agreed on that.
So if you will insert Mr. McIntyre's language, I just was trying to explain why it was necessary to insert Mr. McIntyre's language. The other items that were of importance is you do not define the word non-commencement. What you're suggesting is vehicle park expenses and no construction has been commenced, and you don't define that. I'm just recommending that you define that. And the reason being that Port St. Lucie says that if you mess up the ground, that's beginning construction. Vero Beach says if you have a form board inspection, that's beginning construction. They all are different in how they identify beginning construction. And I'm just recommending that somewhere in there that you make that change. The third thing...
Charlie, stop for just a minute, please. Mr. Chairman, Mr. Satterley, what is our point of construction, start of construction?
Well, I mean, it can be any of those things. It can be, putting a fence out on a site. It's a little squishy. And what we're saying is that that's really not a discussion that we're having, because we've decided that if you haven't gotten a CO, you're eligible no matter how much you've built. I mean, you could have the house erected and, the electric put in probably, and if that project gets abandoned, we would say that you were eligible. I think the issue he's talking about is, again, an interlocal agreement issue, that we can talk about offline in a different format.
That's a point of discussion for this board at a later date in relation to
This board would probably never see an interlocal agreement. Right. That's handled by the Board of County Commissioners.
Carry on.
Thank you, sir. The reason I mention it is because under Section 11125, paragraph A, you say, and no construction has been commenced. And all I'm suggesting is that if you pass this to the board, you probably should, I would like you to at least look at making a definition of what construction is commenced. And then the last issue that I had, that's in this piece of paper that you're recommending tonight, and I'm sorry to have wasted so much of your time, is that areas in absence of local interagreements under Part D, it says, this ordinance shall be applicable throughout St. Lucie's jurisdiction, including the incorporated areas, even in the absence of interlocal agreements. And I just wanted to point out that you have interlocal agreements that are affected by this. And I'm sorry that I wasn't able to provide you with the additional information, and we'll just go from here. So thank you very much, gentlemen.
Thank you. Anyone else from the public?
Yeah, Charlie, before you leave the podium, I did want to comment that I'm actually very pleased that you came. I certainly don't want to give you the impression that I or anyone else doesn't want to listen to you, or that you aren't providing information that is important to us. I'm very grateful that you came, and this is a thank you, and please don't feel that your efforts aren't appreciated.
Well, I appreciate your kindness very much, and I want to be helpful, and I've been working with the county, and as I said, your staff has been extremely helpful. It's just, I'm an expert at this. We know what to look for, and I'm trying to be helpful. And there's a whole bunch of information that, frankly, we'll find out as time goes on, but I appreciate your help. Thank you.
Mr. Chair,
Mr. Adele?
I'd like to ask Mr. Wilson a quick question, if you don't mind, please. We want to be a little bit more friendly.
Appreciate it.
What is your actual main concern? It looks like we have two main issues from all the paperwork that I've read here. And is it just basically the language of the amendment, or the lack of?
You have, in this county, some serious issues involved in your impact fee ordinances. Now, they may not be before you this evening, and I frankly was just trying to let you know that. As far as tonight's concerned, from what your board needs to do, the staff and I have agreed really on, over the last couple of weeks, we have communicated back and forth, and we have agreed on these things. I was just pointing out that you need to put them actually into the piece of paper you're actually sending forward. So there's going to be another day when we speak of this, because in the end, this means millions of dollars to this county, and they're at stake. But
well, in a moment we're going to vote on each of these amendments or changes to the. And my main concern was exactly what would you like to see? I mean,
well, it can't be retroactive. That'll be in court in minutes.
So you needed, you needed some recommendations.
And I just wanted to warn you that about the 3%, which you have taken care of, you need to clean up the definition of construction. The other problem you're really going to have is it has not been litigated whether you can sunset, whether you can say you have to do something in 3 years. You're just making it up. There is nothing in the law that gives you the right to do that.
Have you shepherdized that before? Okay, so you have case law.
Yeah,
so all right, so that's something.
So, but that's something, again, y'all do whatever you want to do. And, you rolls your dice and takes your chances. So, but I'm just trying to be helpful.
Thank you for coming.
Sorry to take up so much time.
Mr. Conde.
Mark, I'm assuming based on this discussion that in the A paragraphs, in the ordinances that we're going to vote on, you've agreed to change the language where it says no construction has commenced to no CO has been issued? Is
correct? Yes.
Okay. So we've, as a county, as a staff, you've agreed to make that change?
Yes.
You're going to insert positive language that indicates that the changes are not retroactive to? Okay.
And then we'll also take a look at the construction, take a look at that construction issue, at
well, I think the construction doesn't matter because that's being replaced with the CO.
Well, right, but we'll look at it just as in terms of how it works with our other agreements.
Okay.
All right, Mr. Conde, we still have a public hearing open. I need to see if anyone else wants to speak at this time. Seeing no one, I'm going to close this section part of the public hearing and bring it back to the board. Now, Mr. Conde.
Okay, thank you. And we're changing each of the A paragraphs at the end to indicate when the permit expired as opposed to when it was issued?
Correct.
Okay. The other question I had was, going through these, some of them have a 3% holdback and some of them have a 4% holdback. Is there a rationale for that, or should they all be 4%? Or
There is, and I know I asked that question of Mr. McIntyre, and I'm racking my brain to remember it, but when he told it to me, it was like, oh yeah, that makes perfect sense, but I cannot remember off the top of my head what he told me.
Strangely enough, that's good enough for me. No,
No, I did. I asked him that very question, and he told me, and I said, oh, that makes perfect sense.
Okay.
And
so,
I've just not, I've just.
What you're saying is the legal department has reviewed that
Yeah.
and...
Oh, yes.
Okay.
Oh, absolutely.
Good. Thank you.
Any other questions of staff?
Mr. Chairman.
Mr. Lowndes?
Mr. Satterlee, if, I asked this question because I sit on another advisory committee with budgets in mind. If we put this in a line item account, Marie, listen up. If we put this in a line item account that we don't use for any purpose, it's not in a bank account drawing interest, is that correct? I'm getting to the point of why do we want to add 3 or 4% onto the refund if we're not receiving any extra monies from it to begin with?
That's not taken away.
We're going to take back 3%? Is that correct? We're going to...
We hold 3 to 4% administrative fee. Is that what you're referring to? That's admin fee for collecting the dollars and
Okay.
all the process that it goes through prior to
All right.
getting into the account.
But we don't ever add percentages to it on the refund.
Well, no, yeah, we do. That is for the length of time that we've held it, we used to pay them 6%.
Correct. And now it's
And
going to be
now we're going to pay
3%.
them... Well, no, we're going to pay them based on a variable interest rate.
Of the Florida prime.
Right.
Correct.
Okay. Why are we going to do that?
Hopefully because we're earning it.
Not if we put it in our own
I think Marie's going to
little
mention...
bag.
It is. We do an interest. We do have interest earning in our accounts. We have some stuff that we put in. The clerks handles that, not the board, but we do have our dollars where we do an interest between CDs to markets. We do an interest in our money. So that's why it's fair, because we don't want to make money out of this. It's fair to return the interest that we earn to the dollars we've been holding. We do an interest. I mean, it's not a lot anymore. It's when if you look at the average that I've showed, there's if you look in your packet that was provided to you, you'll see what the average is. It's real low, but we do an interest on them.
I understand.
Yeah.
But I'm trying to get my head around why we're going to give back to the Florida Prime if we have held, managed, and...
Go to your microphone.
Microphone, please.
If we have managed and held on to that money for 3 to 5 to up to 10 years, and we're going to pay them an interest back on that,
If we didn't use
I'm greedy. I know what the county has gone through for the last 6 or 7 years to make budget, and now we're going to give back some additional money on a refund.
Well, Mr. Chairman, if I might, I think that, Mr. Lowndes, I think that, we have to pay some reasonable, holding costs for having held on to their money for that period of time, and so the rate that we're offering, I think, is just reasonable for having them not having access to that money and now having no impact on our infrastructure. So I think I think it meets the test, as Dr. Nicholas has explained.
Yeah, I think what you could assume is there's a period of time where we haven't spent their money, but we haven't made it available back to them to earn on it. So we're giving them a standard earning, if you will. And we're actually going to earn that. It's not money coming from the taxpayers.
It's fair. It's fairness.
Right.
And I think the other thing that's a little confusing, because there's been so much discussed, is we're not refunding them money back that we are going to be losing. We will still be making a percentage over and above what we're refunding back to them. So we're not giving them back the impact fee plus the 3% that it's going to cost the county money.
Sure we are.
Am I correct in that? we're not going to lose money by giving back the impact fee of the interest. Refunding back their money.
With the interest that we've earned.
Right, the interest that we've earned, like if we're earning 5%, we're paying them back 3%, we're still having 2% of that money that was in escrow. So it's not, no?
No.
I think that's where everybody's confused.
No, I think what we're trying to do is, we don't want to make any money. We want to pay them what we would expect on our investments so that the county breaks even on it. That's really what it is.
Okay, so it's just fairness to the residents.
That's really basically just fairness. That's
Right,
absolutely right.
and our administrative cost is taken care of by the 3 or 4% holdback.
Okay.
So everybody comes out of this neat.
Except the county. Except the county. I would differ on that it only costs us X number of dollars to administrate it.
Mr. Chairman? I don't have any question for staff, but I just want to appreciate the efforts by the county to continue to work with the school board and the cities to enact the education impact fee. It's been really a critical part of our building program for building new schools. It fills that gap of what taxes and revenue from the state does not fill on building new construction. You know, I had a little bit of fundamental concern over this at first because when you pay your impact fee, you basically are entering into a contract with local government that says local government's going to build the facilities necessary for whatever impact you're creating. In our case, it's a school, and to bring a school out of the ground, it can be 3 to 5 years by the time we plan it and construct it and actually open the doors. So, you know, somebody could pull their building permit. In the old days, I'd say we're running along fat, dumb, and happy, and we're building a school and spending the money, and then through no fault of ours, their project fails. We've made a good faith effort to build school facilities. Now they want their money back. It's a little bit of a heartburn, but recognizing that we have to have a certain amount of synergy of new construction to build a new school, and we're generally behind, and we can spend our impact fee money that all the time. I think realistically, the timing at the rate of construction that we've been going, it's probably not going to impact us, the ability to continue to plan and build schools, even though we may be delayed in being able to expend that impact fee money. So, you know, we talk about the fundamental fairness from the developer's perspective. What's the fundamental fairness for local government? We're making the commitment to build that necessary infrastructure that for the impact they're creating, and now we're having to wait for our money. I think it's something that just because of the time it takes, as Mr. Satterley said, to build a new roadway, that all of that planning time, you know, we have to get so many building permits in order to stockpile enough money from that little bit of impact fees that it will not impact our ability to continue to provide those infrastructure services. So with that, I think the school board does not have any major concerns over it. The only concern I had a little bit is the cost of inflation versus the interest money that we're setting on the money now. And if the inflation rate is 5 or 6% and the interest rate's less than that, and we're having to wait until a time certain, that can continue to impact our program. But in a 3-year period, I don't think it's going to make or break the bank. Thank you.
Mr. Chairman?
Mr. Lowndes.
Mr. Satterley, under E on page 2 of the kind of definitions that we've got, the agenda, should the funds, I don't speak in the microphone, they'll come out of the room and slap you. Should the funds remain unspent, a capital account, in 10 years past, the county shall again attempt to refund the fees consistent with the current ordinances. 2 questions. What happens on year 11, and why are we waiting 10 years? Why not, if you haven't done it, and as Charlie asked, 6 or 7, pull the trigger and put it in the general fund?
Again, I think that Dr. Nicholas addressed that, Mr. Lowndes, when he said that, you know, you could pick a year, it could be 6 years, it could be 8 years, but given the length of time it takes to, you know, plan and construct, especially major capital projects, roads, for instance, you know, 10 years is not an unreasonable amount of time.
Mr. Mott?
Yeah,
Mr. Chairman, I have a question of the county attorney. Ms. Young, the draft ordinances we have here tonight, are you comfortable with the language, and do you see any reason that the Planning and Zoning Commission shouldn't move this ahead to the board?
Mr. Chairman, Mr. Mott, yes, I am comfortable with the additions that we've discussed that Mr. Satterley presented, and I certainly concur with the recommendation to move them forward to the board with those minor revisions.
Thank you.
Mr. Chairman. Ms. Lowndes, the 10 years in E really has got to be looked at from two perspectives. One is in the normal course of events where the project does go forward and it's a school impact fee or a road impact fee, we need to be able to not spend those monies on the road because we're not ready to build it, or the Board of Ed is not ready to add those classrooms yet. So we've got really 10 years to spend those monies before we have to give them back because we've demonstrated that we're not going to spend them. Now, the second perspective, and that's been the way it's been in the counties for as long as I can remember.
Since we started a lot of impact fees 12 years ago or so.
Right. Now, when we look at the new situation that's being created, that is, the construction permit expires, the guy's not going to build, he's not going to have an impact. We don't need to build schools, we don't need to build roads. We now make every legitimate effort to give him his money back, and there's nobody to give it back to. We're totally unsuccessful at refunding the money. The question is, do we have to hold it the full 10 years in that escrow account designated for impacts that are never going to occur?
That's my concern,
Right.
Charlie. It's not holding it for 10 years on the development of the other way.
And that's the concern that I brought up earlier. I believe that if the CO is not there, if the building permit expires, and we make every due diligence effort to refund the money, and there no longer is an entity that we can reach to refund the money, we shouldn't have to wait to 10 years, because even at the end of the 10 years, it's kind of loosey-goosey as to who's entitled to that.
Do we wait another 2 years?
No, we might as well deal with the loosey-goosey up front and move that money into the general
My
fund.
point entirely. Moving on, and
Right.
let's get on with history.
Right. And that would be my recommendation, but I'd like to hear what the Attorney's Office has to say about that.
So, Mr. Chairman, and Mr. Grande, my understanding is what you're saying is after the 3 years, we not put it in the capital account to see if we're going to spend it.
No, after the 3 years, in the case where the project didn't go forward, there are no impacts, we were supposed to refund this money. Okay. According to this, we now have a new process for trying to refund the money.
Right.
We don't wait for them to come and ask. We proactively go and try to give it back, which is not a bad idea. So we try once, we try twice, we try 3 times. We know we're not dealing with old records because this doesn't apply retroactively.
Right.
So knowing that we're going to do this, we can keep good records from now on. A company applied, the company has gone belly up, that entity is gone. There is no survivor, there's no heir. So why do we want to then hold the money ad infinitum? At some point in time, that money should go into the general fund and no longer be connected to this project.
It's my understanding, and Mark or Marie can correct me, but after the 3-year period is expired and no one's come forward, we haven't been able to locate whomever might have an interest in that money, that it would go into the capital account. That's correct?
Correct.
And it could be spent. And
Yes.
then after 10 years, if someone pops up and says, you didn't spend it, can I have it? then we
Right.
would deal under that section, but otherwise, that money could be spent during that 10 years. So after the 3-year period is expired, it's available for spending or encumbering it in that account.
I wasn't clear, I didn't clearly understand that aspect of it, Charlie.
But I guess what I'm saying is, in that interim period, from the end of the attempts, the end of the 3 or 4 years to the 10 years, we know that there is no entity to come and ask us for the money. So why are we leaving ourselves liable to refund that money for the remaining 7 years in that 10 years? I mean, the county, there's no entity, the money's there. It does move into the capital account according to the staff.
Right, it could be spent.
So since it could be spent, why don't we just wipe out that account, if you will?
I think there's a couple issues that come to mind. One, again, is potentially that fairness issue that Ms. Townsend mentioned. But also, and Marie, you might want to address this, I hate to put you on the spot, but to keep track of those separate monies when you want to make them all available, as opposed to, well, this is the money that we don't expect someone to come for, this is the money that someone might come for. You want to be able to have all that money available to spend during that 10-year period. So, and as far as the 10 years, and I think it was said that just was a number that was picked as being fair.
And for the other part, it actually is fair. Thank you.
Any other questions for staff?
Mr. Chairman, I've got another question of the county attorney. In making a motion about this, can those ordinances all be part of one motion, or do you have to have a separate motion for each ordinance?
We will need a separate motion for each ordinance. The public hearing aspect for the ordinances was combined because the comments are all the same, but we will need a separate motion on each particular ordinance, similar to what the board did if you were at the meeting last week or earlier on Tuesday with all the MSTUs. They took a separate vote on each ordinance. So if the chairman could just go through the agenda and ask for a motion on each of the identified ordinances.
So we don't need to open a public for each one of them again?
You've already done that. And if the motion is to include the staff revisions or anything else that the motion maker might want to add, if you want to just identify the changes as the changes that were recommended by staff in the presentation, if you want to list them, you may, but otherwise you can just refer to them as the recommended changes by staff.
So the first one up would be ordinance number 13-023.
Mr. Chair, after considering the testimony presented during the public hearing, including staff comments, I hereby move that the Planning and Zoning Commission of St. Lucie County recommend that the St. Lucie County Board of County Commissioners approve the proposed impact fee ordinance amendment as modified to include the replacement of construction commencement by CO, the change of the permit was issued to the permit expired, and the other changes that have been agreed to during this discussion.
Yeah, I had three. One was positively straight retroactivity, eliminate the 3%, and change paragraph A to change from expires, or change to expires instead of issued on the permit.
Correct.
And the CO as opposed to commencement of construction.
Yes.
Okay, that's a good list.
It has to be for a specific ordinance, Mr. Grande.
That's for ordinance 13023 as asked for by the chairman.
Second.
Mr. Vaughn, second. Madam Secretary, roll call, please.
Mr. O'Dowd,
Yes, ma'am.
Mr. Munt,
Yes.
Vice Chair Townsend,
Yes, ma'am.
Chairman Reynolds,
Yes, ma'am.
Mr. Lowndes,
Yes, ma'am.
and Mr. Grande.
Yes, ma'am.
Okay,
Mr. Chairman,
Mr. Mott. Or Mr. Grande, he walked by and it was on my mind.
After considering the testimony presented during the public hearing, including staff comments, I hereby move that the Planning and Zoning Commission of St. Lucie County recommend that the St. Lucie County Board of County Commissioners approve the proposed impact fee ordinance amendment for ordinance number 13024 with the same changes as were made to 13-023 because it's consistent with the requirements of the county.
Second.
Mr. Munn, second. Madam Secretary, roll call, please.
Mr. Odell?
Yes, ma'am.
Mr. Lowndes?
Yes, ma'am.
Vice Chair Townsend?
Yes, ma'am.
Chairman Reynolds?
Yes, ma'am.
Mr. Munt?
Yes, ma'am.
Mr. Grande?
Yes, ma'am.
Charlie, you're on a roll.
No, wait. After considering the testimony presented during the public hearing, including staff comments, I hereby move that the Planning and Zoning Commission of St. Lucie County recommend that the St. Lucie County Board of County Commissioners approve the proposed impact fee ordinance number 13-025 with the same amendments, with the same changes that have been made to 13-023 and 13-024 because it's in the best interests of the citizens of St. Lucie County.
Second.
Second by Mr. Odell. Madam Secretary, roll call, please.
Mr. Munt?
Yes, ma'am.
Mr. Lowndes?
Yes, ma'am.
Vice Chair Townsend?
Yes, ma'am.
Chairman Reynolds?
Yes, ma'am.
Mr. Odell?
Yes, ma'am.
Mr. Grande?
Yes, ma'am.
You're doing good. What do you mean? You're never tired of talking.
Can I have that other mic? Come on. After considering the testimony presented during the public hearing, including staff comments, I hereby move that the Planning and Zoning Commission of St. Lucie County recommend that the St. Lucie County Board of County Commissioners approve the proposed impact fee ordinance number 13-025 with the same changes as were made in the prior approvals because it's in the best interests of the county and the developers therein.
26.
26, yes. That was 26.
Second.
Mr. Munt, second. Madam Secretary, roll call, please.
Mr. Odell?
Yes, ma'am.
Mr. Lowndes?
Yes, ma'am.
Vice Chair Townsend?
Yes, ma'am.
Chairman Reynolds?
Yes, ma'am.
Mr. Munt?
Yes, ma'am.
Mr. Grande?
Yes, ma'am. I defer to Commissioner Townsend for the next...
Why is that? Are we on 28?
Because
27.
27.
Because I'd so much rather listen to you than me.
Thanks, guys.
What he said.
After considering the testimony presented during the public hearing, including staff comments, I hereby move that the Planning and Zoning Commission of St. Lucie County recommend that the St. Lucie County Board of County Commissioners approve the proposed impact fee ordinance 13-027 with the same changes as stated above in the prior ordinances because it's consistent with the requirements to bring into change and it's in the best interest of the residents and development.
Second.
Second by Mr. Munt. Madam Secretary, or Grande, I don't know, I'm sorry, I keep... Grande.
Mr. Odell?
Yes, ma'am.
Mr. Munt?
Yes, ma'am.
Mr. Lowndes?
Yes, ma'am.
Chairman Reynolds?
Yes, ma'am.
Mr. Grande?
Yes, ma'am.
Vice Chair Townsend?
Yes, ma'am.
Ms. Townsend?
Are we on 28?
28.
After considering the testimony presented during the public hearing, including staff comments, I hereby move that the Planning and Zoning Commission of St. Lucie County recommend that the St. Lucie County Board of County Commissioners approve the proposed impact fee ordinance number 13-028 with the consistent changes in the above-mentioned ordinances because it's in the best interest of development and the residents.
Second.
Second by Mr. Grande. Madam Secretary, roll call, please.
Mr. Odell?
Yes, ma'am.
Mr. Munt?
Yes, ma'am.
Mr. Lowndes?
Yes, ma'am.
Chairman Reynolds?
Yes, ma'am.
Mr. Grande?
Yes, ma'am.
Vice Chair Townsend.
Yes, ma'am.
You want to get one more? Come on.
Thanks, guys. After considering the testimony presented during the public hearing, including staff comments, I hereby move that the Planning and Zoning Commission of St. Lucie County recommend that the St. Lucie County Board of County Commissioners approve the proposed impact fee ordinance 13-029 with the above-mentioned changes in the prior ordinances because it's consistent with staff requirements and it's in the best interest of development and the residents of St. Lucie County.
Second.
Mr. Munt, second. Madam Secretary, roll call, please.
Mr. O'Dowd?
Yes, ma'am.
Mr. Munt?
Yes, ma'am.
Mr. Lowndes?
Yes, ma'am.
Chairman Reynolds?
Yes, ma'am.
Mr. Grande?
Yes, ma'am.
Vice Chair Townsend.
Yes, ma'am.
Ms. Townsend, you want to do the last one?
That was
I
it.
know, I just wanted to see if she was paying attention.
I'm paying attention.
All right. Other business?
Mr. Chairman, if I could just interject, as we discussed at the last meeting, we now have a public comment section of the agenda, and that was actually after the minutes, and we went directly into the ordinances. So if you would please include that, if anyone has any general public comment to make.
Okay, to open up for any general public comments? Seeing none, bring it back to the board. So I'm supposed to follow these guidelines? Okay. Any other business?
I would just like to make a comment, Mr. Chair. I would like to thank staff. I think you have done a great job at this, and I know it was a bit confusing this evening. And again, thank you for coming because, as you stated, it is public comments, and it's important that the public have the right to speak. So thank you for attending, and then thanks, Mark, and let staff know that we appreciate what you all have done.
Mr. Sadley, anything?
Mercifully, no.
Motion to adjourn. Second.
I vote no. This has been too much fun. No. Thank you very much. We will see you next month.